So good evening to all of you in Singapore, and greetings to everyone. I can't tell you how absolutely delighted we are, Patricia and I in the center, to have Professor José Alvarez giving this what we call special bonus lecture. And I have to say that the first thing I'm going to say is that Professor Alvarez is also a member of the CIL's International Advisory Panel, so he's part of the CIL. Now, he has an incredible history, career path, so rich that I can only say a few things because we certainly don't have enough time to go through all of it. But first of all, he's currently a Herbert and Rose Rubin Professor of International Law at NYU University. He is also the director of the NYU US Asia Law Institute. Before NYU, he was the Hamilton Fish Professor of International Law and Diplomacy, also executive director of the Center on Global Legal Problems at Columbia Law School. He also taught as a professor at Michigan Law School, George Washington, and also was at the Georgetown Law Center. He is former president of the American Society of International Law and the previous co-editor-in-chief of the American Journal of International Law, a member of the very prestigious Institut de Droit International. He is lectured at the Hague Academy of International Law. He was also attorney advisor with the Office of the Legal Advisor at the U.S. Department of State. So he's published so much. So I will stop there because I think we want to spend the time listening to Professor Alvarez, who's going to talk to us today about publishing and doing research. So Professor Alvarez, again, we're so thankful to have you here, and the floor is yours.
Okay, so thank you so much for that generous introduction. And a few words about what this talk is about. I've presented this mostly to our JDs and LLM students here at NYU Law School and a few times to PhD candidates around Europe. But I wanted to stress that it's from a particular perspective. It is what academies, especially in law, appreciate in international law scholarship, particularly in the US, the UK, Canada, and parts of Europe. So it is a particularly parochial talk because, as you'll learn, if you don't know already, from Anthea Roberts' work on comparative international law, what people consider around the world to be good international law scholarship varies from country to country and from region to region. So only you who are listening in can tell me how much of what I say, which is focused, as you might predict, on my experience in 10 years as a board member of the American Journal of International Law and 5 additional years as co-editor-in-chief, about what's appreciated, at least in this part of the world, about what is good, solid academic scholarship. So with that caveat in mind, I'll start, and I think most of you have seen already, I hope, or have access to these very crude PDFs. I apologize that the quality isn't as good as it should be, but I want to start here. So once upon a time, and let's just say when I started teaching in 1989, this was the places that you were expected to publish. If you were an academic, maybe you'd publish 1 or 2 pieces that are practitioner-oriented, particularly if you have practiced before. And we know what those pieces tend to look like. If you want to go to a law firm and you see what a short description of the latest case or the latest statute looks like, it's basically descriptive pieces that are quite useful for people who practice. CCH publications in the US would be a place to publish them, but also it's just, you will see them as memos to clients, etc., in say, law firms. There are NGOs and think tank reports. There are student-edited and peer-reviewed journals. In the United States, for instance, there are 73 student-edited journals specializing in international law. I repeat, 73. And that means that a single law school, say the last one I was associated with, Columbia, had more than 14 journals in the same law school. And that meant that there was about 2 or 3 that might consider an international or foreign law piece within the same law school. So we like to tell the students that there was a human right to be published. That is, there are so many places that you can publish that the truth is it's hard not to be published. And that itself presents a problem, as I will discuss. Peer review journals are not done by students. They are by peers. That is, they fellow practitioners or mostly academics judge the submissions. And in the US, there are 8 peer-reviewed journals specializing in international law. The most prominent and the one that is most cited around the world is the American Journal of International Law. But there are others: the Indiana Journal of Global Legal Scholarship, the Journal of World Trade, and so forth. Another place that you can publish, both when I started and now, are book chapters and edited books. The Oxford Handbook on Everything. So the Oxford Handbook on International Adjudication, on International Criminal Court, the same as CUP does the equivalent. Then there are books that are scholarly books for a general or specialized audience. Many of them are transformations of dissertations, PhD projects or JSD projects that someone has done. Then there are treatises, case books, or other books designed for classroom use. And then all of these are published by different publishing houses with different types of reputation. One distinction between a large and a smaller house, say CUP versus Hart and Edgar, and there are benefits to both in terms of you get much more commercial marketing, for instance, from a CUP or an OUP, more access to more eyes and more markets, but you get more personalized attention and perhaps closer editing from a place like Hart. So this is the world as it was. This is once upon a time, let's say. I could have started that way. And in those good old days, in 1989, when I first started teaching, I had no real publications, just a student note, and yet I broke into teaching. Those days are long gone. Back then, you could not only break into teaching just based on the promise that you will teach and write, but also it was expected that after 5 or 7 years, if you got tenure, it would be because in those 5 to 7 years, you might have published 3, perhaps 4 articles. So a little less than 1 a year, and the expectation was that's how it would proceed forward. So it was a relatively civilized existence where you could have summers entertaining under the trees and contemplate deeply with respect to your law review articles and let it mature over time as you think about this greatly. It was an idyllic thing that could be something out of a French movie. You know what I mean? So that's then. Now, the world looks a little bit like this. So if you now go, and this is not the current version, but if you go to your computer now and you click on the American Journal of International Law to the Cambridge University website, you will get something that looks like this. The physical journal on one side, and AJL Unbound, which Benedict Kingsbury and I co-created when we were editors-in-chief, and now is going great guns. AJL Unbound is the web-based version of the American Journal in the physical print. It does not print the same thing. It is completely different. The AJL Unbound version, which is different from AJL Talk, or the Harvard Law Review, has its own ways-based system. Many American journals, certainly, and many Europeans ones, have a web component, but AJL Unbound functions on the basis of invited symposia. We have a board of editors that is a subpart of the American Journal of International Law Board of Editors that's responsible for AJL Unbound, and they come up with ideas like, as you see here, let's do a global migration law and invite select people to write essays. The essays are no more than about 3,000 words each, and they could be, as you see here, anywhere from 4 to 5 essays, and they're published relatively quickly, so they can seize on a contemporary issue with some depth. And you could expect that some of the people who write here will ultimately produce a far longer version in some journal. It doesn't have to be in the American journal. Now, the physical journal, which some of you may still be old-fashioned enough to actually pick up from the library, and it looks like this. This is actually what it looks like. I know students who have gone through 3 years here and have never picked up a book physically from the law library. They will just look at the physical journal or Agel Unbound online for a particular thing they're looking for. And that's one of the things I want to suggest, which is the web has transformed not just how articles are published, but how people look at them. So that, for example, if you look at the physical journal, you will discover that there are different sections of the physical journal, and that includes 2 or 3 lead articles that could be as long as 25,000 words. That's pretty long for a law review article. That's why there are only about 2, maximum 3 per issue. Then there are current developments, which is a more descriptive piece by, say, the U.S. member of the International Law Commission talking about the work of the International Law Commission, Sean Murphy, or say an up-to-date piece on the latest work from the latest product by the Human Rights Council, for instance. Then there's international decisions, and those are prominent decisions from, say, Supreme Courts around the world or international bodies that have significance to international law. The editor for that section is Harlan Grant Cohen, and he also gets ideas from people and suggestions about writing for that. If you're a young author, international decisions are a good place to think about writing, and they're relatively straightforward pieces. If you know, for example, that your Supreme Court in your country has a very prominent, important decision on international law that is not going to be appealed, it is the final decision, you could suggest writing about that to Harlan Grant Cohen. Contemporary practice of the U.S. is a section that looks a bit like this. So the next page, you see what it used to look like.
I apologize for interrupting. I don't think the PDF is shared.
Oh.
It's not on the screen.
It's not on the screen. Okay, let's see. Is it now shared?
Yep. Perfect.
Okay, sorry about that.
Perfect.
I don't know.
Oh, no. That's no problem.
So, so basically that first page was just the introductory page between Agel and Agel Unbound. The contemporary practice of the U.S. Looks like this. Back when it was done by John Crook, these days it's now done, by the way, by Jean Galbraith. It's a bit shorter, and that is also because of the web. So what has happened over time is that there are more places to find the contemporary practice of the United States, and therefore it was not necessary for the journal to do that. And so what over time has happened is we still have contemporary practice, and that's done by one person. This is not something that is outside submissions, but it could be a few months of events that are collapsed into a contemporary practice of the U.S. section. And then there is book reviews done by Richard Bilder. Again, if you have a book that you don't have any connection to the author, but you think you would be a particularly good book reviewer, that's another way young authors get published in the physical journal. Agel Unbound, however, is the way most young authors, diverse authors from all over the world are breaking into Agel, and that is through these shorter essays. Now, but what this suggests, just how you find the journal and the fact that it now has a web component, is a bigger change. So as I said, when I started, it was once upon a time, that's how you published. You published in one of these venues, basically articles, books, chapters. Today, the impact of the web is that you publish in all sorts of places, and you do them in different forms. So there's the tweet, there's the short or long blog, and some of those blogs are prominent to you, I hope. Opina Juris, Just Security, Agile Unbound, Agile's Talk. Then there's public policy journals. Then there are the think tank NGOs, as always. And then there's, as always, the published article, book, chapter, and book. But one difference is that in order to, when you publish an article these days, you push it, or somebody does, your institution, a center, someplace else, pushes it out as a tweet. See Professor Alvarez's latest article on blah. And if you don't do that, you don't get hits. And you need to have hits. Now, I am not I'm not on Twitter. In fact, I have a scheduled appointment this afternoon to get on Twitter, but I haven't yet bitten the bullet. But most of my colleagues, certainly younger ones than I am, are there. And that means that you have a progress of an idea. You may get an idea that you publish in 140 characters as a tweet, and then you own it. And then you publish it as a short blog, then as a long blog, ultimately as an article, and perhaps someday as a book. Then you rinse that idea, you put another tweet off of whatever you've published, and repeat. This is the work of an academic these days. It is working on, in other words, both social media as well as the ordinary forums for scholarship. This has a lot of benefits. Obviously, you can address contemporary events much faster thanks to all of these venues. You can try to affect policy directly and therefore purport to be a public intellectual, which many law schools, for example, value quite well. And it means that you can get out there with an idea without being an established publicist, that is, say, somebody who has a prominent column in the New York Times, for instance, editorial page. It democratizes the academy so that there are more younger people who can make valued contributions, even in a short or long blog. And it means that anybody can participate. And that invisible college that Oscar Schachter used to talk about is a great deal bigger and less invisible. That is, there are more people publishing under their name under this version. And this is something that academies value. So, for instance, NYU had a search, the last search for a dean at NYU. I was surprised, but maybe I shouldn't have been. The first line on that candidate's CV was the number of Twitter followers they had. That gives you a sense of how this is now important to even prestigious law schools. They want to know that you exist on social media, and if you aren't, they want to know why. Now, the downside of all of this is suggested by this little piece by Joseph Weiler that he published in 29 Agile 673, and the title tells the story. Instead of you either publish or you perish, he's suggesting that these days you publish and perish. That is, he thought that it was a very bad idea that we were pushing younger scholars in particular to publish before their time, before an article has time to simmer, before an article has time to mature. This means that, for instance, we now are hiring people in the academy, not like me in 1989 with 0 publications, but typically the entry-level hire at NYU and many other law schools has 3 to 4 published articles before they even step foot into the academy. And then the expectation is that they will continue to publish at that enormous rate thereon, not just one leisurely article a year or less, but much more, and of course, publishing in all of these forums and pushing out the material. It is also true that at least some publishers will want to know from your CV or your background before they look at your book project whether you exist on social media. Because after all, if you exist on social media, maybe your book will sell more. Now, I'm not sure that CUP and OUP will admit that they look for this, but keep in mind, they do have a bottom line, and they could publish many more books than they do. And I think that at least some of the books they publish are very much aware of that trajectory, the social existence of the particular author. The downside of all of this is that, of course, it means that people publish things that shouldn't be published. And that doesn't sound like a very bad thing, except that it's often hard to get rid of things that are out there, as some of you may know. And I'm not just talking about academic stuff. So once you publish it, you may be embarrassed by it because it's filled with mistakes or you've changed your mind, which of course is not uncommon because it's about a timely question. And then you have to explain away why you were wrong or why you published something that was filled with errors. So one advice that I would have is that you can't buck all of these trends, but you can be a bit careful and should be careful about publishing before you think it has that quality that you can live with something that will possibly exist for forever out there. And so be careful what you publish. And I think the old advice still goes. You should be presenting at a conference. You should be presenting to your friends so that they can point out what's wrong with the piece. Because these days, with so many student-edited journals and some peer-reviewed journals that are still desperate to publish, it is too easy to publish bad stuff. And I can't stress that enough. Another thing that has changed with the web is this kind of stuff. So here's an article by my colleague, an editorial on the West Bank and International Humanitarian Law by Ted Marone a few years back, published in 2017. You'll notice if you go to the Cambridge Analytics website of AGIL and AGIL Unbound, it has things like this: an attention score, Twitter demographics. It tells you that this particular article is at the top 5% of all research outputs. But more importantly, it tells you when, and this is now old. If you go in, it'll be more updated than this. But it's mentioned at this point by 10 news outlets, 2 blogs, a policy source, 129 Twitters, and then it even tells you who is looking at this and where are they located. That is, where are these downloads coming from? Who is reading your piece? Needless to say, this kind of demographic information about readership is not something we had ever before. And it's both good and bad because, of course, it motivates you to make sure that your piece is tweeted about so that you get more eyes on this. But it's also useful in terms of which countries are looking at this. And then it even does a breakdown by what kinds of readers, students, master's degree students, PhD students, others, professors. And so, for example, my colleague Ryan Goodman, who's created Just Security, which is about essential security, national security issues, including international law. He's very proud of the fact that according to their demographics, which they follow closely, a great deal of their influential readers are at the Pentagon, which is exactly the place that they want readers to appear. So this drives, of course, even somebody as, let's just say, established as my colleague Ted Marone, once he sees this kind of outputs that is for the American Journal of International Law, he's done quite well. And this tells you that he was in the top 5% of all research outlets. So ever since then, my colleague Ted Marone wants very much to be published in AGIL Unbound, especially because of the types of readers he gets. So that gives you a sense of the kinds of information that's now available, but also the types of things that people, academics, now can look at to judge whether your article has eyes on it and whose eyes are on it. Now, this particular thing is where I look under the hood to expose, let's just say, expose to transparency a bit, the 2 leading peer-reviewed journals in international law published in English. Here's eAgil. So eAgil, this is the last time I checked, about 350 article submissions per year, most of which is predictable, 250, are rejected, usually at a preliminary screening stage without being sent to peer review, but that can take up to 6 weeks at eAgil. If they're sent to peer review, that process, which is about 3 peer reviewers, anonymous, they don't know who you are and you don't know who they are, That process can take another 6 months. And then the author gets an accept, reject, and revise and resubmit. The most common is a revise and resubmit. And there's now a new category, promising but needs a general overhaul. And it's up to the author how much they want to do with that. And then that can result in another 4 months delay between revision. And therefore, in order to get one of these articles through this process, it can take 12 months, a whole year, from initial submission to physical publication. But in the meantime, both EJIL and AJIL and most journals now don't mind if you publish it in SSRN or in your, say, university working paper series, so that it gets a fair amount of eyes, even as a working paper. I would suggest that even before you put it on SSRN or as a working paper, it should be as mistake-free as possible, because people will look at it and perhaps even cite it even before it is published. Now, the one reason to do both EJIL and AJIL is this point at the end. You will get feedback. Free feedback is invaluable. I have been in the academy for many, many years, and I can tell you that it is not that often that a colleague will spend the kind of time that one of these reviewers spends looking at your piece and giving you feedback. Now, of course, it may take you a few whiskeys to go through these reviews, which are often quite cruel, but you will get enormous benefit at the end of the day. And even if you decide not to publish in EJIL, or they decide not to publish you, you still get the benefits, and these revisions can make for a better article someplace else. AJIL is similar, 350 to 375 submissions. Exclusive submissions are not required, but you'll get expedited consideration if it is exclusive. Initially, and we started this, Benedict and I, we submit the articles to student editors here at NYU, now at Duke, because Larry Helfer and Curtis Bradley are the new co-editors-in-chief, and they're both at Duke. And those students will write the strengths and weaknesses of the particular piece and make a recommendation, and the editors-in-chief are free not to accept that or not, but it means that those articles get at least that initial screening within 5 days of being submitted. That is considerably faster than most peer-reviewed journals, and as you see, faster than EJIL. And then the co-editors-in-chief decide whether the article is worth a double-blind peer review, and they need, under AJIL rules, 2 of the members of the board, and you can look those up in the physical AJIL. You will see who the members of the board, they're the folks at the top are about 25 or so, and then the honorary members who are over 65 are also peer reviewers, but 2 of those people have to vote yes. But now they have reduced that peer review to 2 to 3 weeks, which is incredibly fast for a peer review. And here's, so in the first 6 months of 2018, the last time I had records for this, they had 194 submissions submitted in those first 6 months. 12 made it to board review and final decision, so most were rejected at a preliminary stage. Of the 12, 6 were accepted, and almost all of them are revise and resubmit. Almost nothing gets published straight like that without any change, and 6 were rejected. You see the numbers, but again, even rejected manuscripts get feedback, so that is a reason to submit to a peer review journal that gives you that kind of feedback. Common reasons. So the first 3 here are totally within your control. That is, there should not be a rejection based on this if you've done your homework. You should not be submitting an article to a journal that you have not looked at to see if they publish the kind of foreign law, comparative law, international law piece that you are writing. So it's the wrong subject or the wrong audience. You can't submit a practitioner piece, for example, and expect to be a lead article in AJIL, or it's the wrong style. You can't submit an editorial to AJIL because editorials in AJIL are restricted to the board of editors. That's in the instructions for authors. So therefore, the first three, which are common reasons for outright rejection, should be something within your control. The next group, 4 through 9 here, are the reasons that are much more subtle. That is, this is typically things that either the student reviewers at a preliminary stage or the peer reviewers will pick up. You have been preempted. That is, the article lacks novelty. You should have done a literature search and you would have discovered that 1, 2, 3 authors have said this before, and you have not added anything. Poor research. You haven't done the sufficient grounding in the relevant facts and the relevant law to convince somebody that you have done a good job. You don't have a clear thesis. You'd be surprised how many articles are written and they're very long, but you're not clear what this was about. This has to be clear from the first thesis statement that is in the first paragraph. I have a separate talk talking about how to write in law reviews generally, and that thesis has to be clear up front and should be repeated at least twice, especially in the beginning and the end. You should deal with objections to your thesis, anticipate them, and answer them. And then there's the category often for non-English speakers, but surprisingly also for those who have whose only language is English. There's surprisingly poor grammar, informal writing, and loss of a particular skill. Each paragraph should have a topic sentence, and the paragraph should deal with that topic sentence, for instance, so that if somebody wants to skim your article, they should, in the ideal world, be able to read that first topic sentence of every paragraph and be able to follow more or less what your argument is. And then there is the problem where the footnotes don't exist or they don't support what's there. Other problems may not be the author's fault. You submitted something, but at the same time, the journal has already committed to publishing in that general area on the International Criminal Court, and therefore they're not going to publish that same piece. So the typical tips that authors get from, and as you see, I've included in the next page, authors' tips from CUP, Cambridge University Press. These are the types of things you'll get. You need more research on topic X. You need more depth of discussion. You need more care with expressing this argument. Here's an example of your grammar problems. We won't fix all of them for you, but we'll show you one paragraph in one sentence to give you a sense of the general problems you have, the counter arguments. You see this facts and fictions page gives you a few things that may surprise you, but most articles in peer-reviewed journals like AGIL are written by academics, 65%. In 2018, the last year we were co-editors-in-chief. Much fewer are written by students, and if they are, they're usually international decisions, book reviews. About the same number are co-written by practitioners, and of course, as you might expect, the largest percentages are authors based in the US and the UK, and this has not changed all that much, I think. But the most popular topics: international economic law, trade investment, legal theory, international criminal law, law of armed conflict. This is good or bad. If you are in these areas, it's among the most published things. So it's not necessarily that they're ready to publish yet another piece on investment law, but the least popular topics are revealing. These topics, African, Asian, Pacific, Latin America, East European perspectives, law of culture, gender, development, these suggest one of two things. Either not enough submissions are written on this, which was my experience, or the ones that are submitted, the peer reviewers did not like. And that could be a matter of editorial bias, for instance, against some of these topics. But they arguably present opportunities for folks who want to publish in these less common areas. So the tips from CUP repeat some of the things. So I just included this so people can see. So some of these obvious points: read widely. This is the preemption check, where you read widely on your research to see what is topical. The literature search can test your topic at a conference, expose it to scrutiny by your friends, by professors. If you wrote it for a course, that is often helpful if you get professors' advice. And choose the appropriate journal, which means do your homework with respect to that journal, and choose the appropriate form for that journal. So I'm not going to go through all of this advice. I think all of this is good advice. Some of it is quite obvious. You would not want to submit something that is not written in clear English. It should be as complete as you can make it. You should not be submitting what you consider to be a first draft that will be, quote, fixed later on. It should be as finished, as taken care of as possible, and then you will have to revise, because that's invariably how it happens. Now, how you do research is the subject of other talks that I and others give at NYU. Certainly, we have talks by research librarians that, for example, do this kind of thing. Our library also has, and I think these library guides are available to anyone, library guides. And this one is, for example, a library guide on researching general sources of international law. We have specific guides to tell you about researching trade law or investment law. And so, and also we have research librarians, or at least we do now. Whether we'll survive financial constraints, we will see. Now, the next section is in this talk, and I know that I'm running close on time, I'll try to go through this quickly, is the substance. So what does get published? What is the content of some of these articles? One group of contents is ageless topics on sources of international law. So here are some: Customary International Law by Anthea Roberts, A New Look, Comparing Traditional and Modern Approaches. The Role of Specially Affected States, a new look at their role in creating custom. And then here, The Decay of Consent in Treaties. So these topics, treaties, custom, general principles, the classic sources, so long as it has a new spin, they are appreciated, because they are likely to be articles with legs. That is, they will stand the test of time. They will be read in perhaps 5 years or 10 years, which is the ideal lifespan of a lead article in something like AGIL. And so this is attractive. And often these articles on sources come up with a new angle, either new actors that are involved in treaties, custom, general principles, or new process by which they're created, or a challenge to the three sources altogether, suggesting that they're new sources. Then there's the traditional doctrinal piece that takes a particular issue, like the outer limits of the continental shelf, or an MFN clause, and gives a new spin on its interpretation. I do stress that with a journal like AGIL or EGIL, what you want is that new spin. It's not enough just to say, here's the doctrine of continental shelf as applied to this particular continental shelf. It'll look like this. It is more theoretically ambitious, as these two articles are. Simon Batterford and J. Benton Heath were my two former students, and they wrote what has become quite a controversial piece, reinterpreting the most favored nation clause in terms of treaties. It was so controversial that when we published this in the journal, we had a response by an established investment law scholar, Stephen Schill, responding to it. If something draws a response in the same journal, you know that that's important. The other pieces here show you other types of scholarship. Ted Marone writing on law and literature, Shakespeare, and legal implications. And then this piece, and notice these are called notes and comments, not only because they're shorter, but they're less theoretically ambitious. Presidential tariff authority. What is that? Well, since Trump started saying things about unilateral tariffs, somebody had to go back and find out what's the statutory authority for that. And this is a short history of the statutory authority in U.S. law for unilateral tariffs. And this is a current development by Sean Murphy, as I've mentioned on this. The classic, another classic type is taking a historical look at a doctrine. In this case, a historical look at the exceptions clauses, And this is a classic look. If you have new access to new materials, for instance, this is the type of thing you would get. And here you have another look at history, looking at the history of the norm in the UN Charter, preceded by the League of Nations, that barred secret treaties. How did that come about? How often do states violate that? So that was also an NYU student who did this initially, I suspect as a project, as part of her dissertation here, and then it became a law review article. This is the type of thing that the American Journal publishes, and some perhaps other journals out there, which is internal foreign relations law to the United States. That is typically war powers, statutes that implicate international law. So this is U.S. law that has foreign law elements. And so that is a part of U.S. law that is published by American Journal. This gives you a sense of what those articles might look like, the war powers legacy of the Obama administration. And here is a perspective by Harold Coe, former legal advisor and another State Department lawyer, on how the U.S. saw the crime of aggression in the statute. This particular journal is one that I do highly recommend to people if they are looking for methodological approaches that have been common to especially the American Academy, but have now spread to other regions. And so this particular symposium back in 1999 is still relevant. You get Enlightened Positivism by Bruno Sima, where they talk about the traditional sources, but suggest there is some flexibility about accepting soft law, for instance. You get policy-oriented jurisprudence from the New Haven School, international legal process, which is the Chase and Chase look. You get crits in the form of a letter to the editors of the symposium by Marty Koskiniemi. You get a mix of international relations law and international law that's started by Anne-Marie Slaughter, in this case by Kenneth Abbott. And you get feminist perspectives by Hilary Charlesworth, and then law and economics by Dunoff and Trackman. And basically, these articles just tee up these particular methodological approaches. We have added to them over time. So the law and economics, for instance, is now represented many years later by Alan Sykes. And then we have new methodological approaches. The Global Administrative Law Project started at NYU. This is a typical GAL project, Richard Stewart. And then you have empirical methods. So here is Jess Powlin looking more closely at who are the arbitrators in investment and trade disputes, and what do they tell us, their backgrounds, what do they tell us about the law. Another area, and here is the TWAIL. So this is Third World Perspectives on International Law. It's a version of crit theory, but from the perspective of Third World. And here is a very prominent scholar from India looking very critically at customary international law and its bias, especially against the Third World. Another new methodological approach is introduced here by comparative international law. It's not really new. Eric Stein had been doing it for quite some time, but Anthea Roberts and others have discovered that what we call international law is actually different from country to country, region to region. And this symposium explores some of those differences. They're now the subject of both a comparative international law book edited by, among others, Roberts, and of course, Roberts' own book is International Law International. If you look closely at this, this is one reason I started with the caveat that what is appreciated as good international law scholarship in the US or Canada may not be what is appreciated in your academy, which may value more straight doctrinal approaches, may not value multidisciplinary approaches like IR theory, or don't quite know what to do with it. Now, at the very end, and I know I'm completely out of time now, and this is, by the way, another comparative piece. Obviously, China is very hot right now. And so this particular author, based in China, formerly at Xiamen, is doing a piece just describing what Chinese courts do with respect to international law. Notice it's a note and comment because it's mostly descriptive. That is, it's not a new theoretical angle but it is quite interesting, of course, for comparative international law perspectives. The rest, the few other pieces that I have are a selection of the most highly cited international law pieces in the history of the American Journal. I picked these to show you because I think it's useful to look at what pieces with legs look like. So this is a leading piece from 1992 at the height of the aspirations at the end of the Cold War that they will be more growing democracies, and not only will there be more of them, they will be required by international law. Now, that piece continues to be cited, but more like CF, like, really? Did we really believe this? Now, I'm sitting in the office where Tom Frank wrote this piece, and I particularly appreciate it because it is clear as a bell what the thesis is. It is clear as a bell why he thought there was a human right to democratic governance and the component parts of it. So it is a wonderful piece, despite the fact that it has a particular time sensitivity to it, and we probably don't believe it's true today, but it is a wonderful piece in terms of the skill of what it takes to write a crystal clear piece that everybody can quickly understand. And all of these pieces, by the way, have the same quality. So here's a classic Prosper Veal piece translated from the French, where he attacks brutally soft law, or what we now call sometimes informal law, and makes a great deal of sense while he does so. It is still cited for the proposition of that. In fact, it was a recent symposium in Agile Unbound showing just how relevant this debate is. Just to show you, and I wrote one of the pieces suggesting, look, we may make fun of what Prosper Veal said about informal law, but if a lawyer asks you what the law requires and you tell them, well, maybe, that's not really what the client wants. The client usually wants to know, is it legal or not? And therefore, there is a point to Prosper Veal's criticism of informal law. And so some pieces are widely cited because they establish a new field. Eric Stein's piece on EU is that classic piece that establishes EU law and the role of the European Court of Justice in creating that new law. And it's also, if you look at that first sentence, beautifully written. It just because it's a law review article doesn't mean they can't be a little bit of class. Tucked away in the fairyland duchy of Luxembourg and blessed with benign neglect is this Court of Justice. Now that's grabs you, right? How many law review articles start that way? And it's one of the reasons it remains widely cited. And then finally, the last piece, Feminist Approaches to International Law, another path-breaking book, article back in 1991, the first feminist critique of international law, certainly published in the U.S. Academy by three giants in the field. And this article continues, obviously, to have legs, as you see from just a recent piece that I picked at the bottom here, where Nikki Grossman, inspired by that article and all the feminist literature, takes a look at the difference it makes to have gender represented on international courts. So let me stop there. Hopefully there's a few minutes for, I'm certainly willing to stay past the hour if that's necessary. I apologize that I did not get to talk about, as I feared I won't, book projects. I did include as the last page the advice that Cambridge University Press offers for those people who submit book projects, and I just leave it there. Thank you for your attention, and let me try to get rid of the share function so that I can stop share and show up physically.
Well, while you do that, let me just thank you. That was an incredible tour of many issues related to publications from the times of, as you were saying, almost bucolic times when there was the luxury of time, which clearly now there doesn't seem to be. And I have to say the whole role of social media. I have recently discovered Twitter, and I'm learning about Twitter, trying to build up my followers as well.
So this is the lesson plan. I wasn't kidding. Getting started on Twitter, and I was sent a document so that I know what I'm supposed to do, and they sent me a picture of one of my colleagues' Twitter feed so that I know what I'm supposed to put. Now, all of the participants that are under 30, I'm sure, already have their Twitter feed. I don't have one, so I have to learn whether this is worthwhile. But I can't stress enough how this is now part of your job if you're an academic.
Yeah, no, I think the fact that you brought that out, I really didn't. I mean, the fact that a dean application starts off is telling in and of itself right there.
And I won't tell you who that candidate was, but let's just say the Twitter following was in the millions.
Oh, really? Oh my God. I have an inferiority complex now. Oh, it's amazing. But, this was fantastic. I think in a short period of time, and I know we could actually go on, you have given so much valuable information. And I have to say, though, and coming from the Asia, and I'm also from Turkey as well, there is, an imbalance. And I think that comes out that they recognize, quote unquote, recognize journals and publications are Eurocentric or shall we say Western. So I don't know. I know we'll have some questions, and there are some efforts to counterbalance that, but I think that's a big challenge, particularly in all fields of law, but particularly international law. But anyway, this was a fantastic lecture, but let me see. Zhifeng, you're going to help us with this. And again, Zhifeng is our assistant, and he's a future star. I'm sure he's going to be publishing in some of those top journals, actually.
Thank you, Prof. I think someone has a question. You can unmute yourself.
Yes, thank you very much. Thank you, Professor Alvarez, for the insightful lecture. I just wanted to ask, when writing an article or a law review, what is the outlook and review of articles that seem accusatory and seem like memorandums? So, for example, topics such as holding a state responsible for a violation of human rights, or holding that a state's actions have violated international law. So those articles really come off as arguments, really start to establish the responsibility of a state instead of, those more conventional articles of exploring a doctrine, exploring an interpretation of international law. And there is a cat at my window. Please don't be disturbed by that. Thank you.
So there are plenty of articles in U.S. law reviews that are what you call accusatory. There's nothing wrong with them. Of course, they're far more common published by an NGO, right? I mean, that's their bread and butter, is to accuse a state of something. So, for example, it would not be uncommon now to have an article or several, in fact, I can think of several, as to whether or not what's going on in China right now with respect to some groups and internment camps is a crime against humanity or genocide. The pros and cons of branding that, for instance. So Philippe Sands, for instance, has a short blog post that suggests we shouldn't get caught up in calling something genocide or crimes against humanity because we often get caught up in that. We should recognize the facts for what they are. But the truth is that it does matter to many governments whether they call it genocide. It certainly mattered to the parliamentary committee in Canada that declared it was a genocide. And I suspect that, for example, incoming President Biden will be pressured on this very point by human rights advocates. So there's nothing wrong with publishing those, so long as they're scholarly. Presenting an argument is precisely what you want. It will certainly be a clear thesis. The thing to make sure is that it isn't a rant, that it isn't one-sided, that you anticipate what the other side says, and you anticipate the very downsides of what you're doing. So it's always about how thorough is the argument? Has somebody already made it before? What are you adding new to it? But I think having an argument, whether it's accusatory or not, when I first heard you say accusatory, I immediately thought it's a personal attack on another scholar. Okay? And by the way, I've done that. Okay? So in fact, that's one of my favorite law review articles. Find somebody whose argument is prominent because they are prominent and destroy them. Okay? Politely attack the arguments, not the person. But that is a formula, right? I've done it with very prominent people, okay? And it establishes, but again, you have to do your homework. You have to make sure that the attack is fair and the attack is not personal. It is about the arguments. So both accusing a state or accusing another scholar of having a poor argument are totally open.
Thank you very much for the answer.
Thank you, Professor. I would also like to take this opportunity to notify the participants on the Facebook live stream that they may submit their questions on Facebook by commenting on the post.
See, there it is, social media, Facebook. I think that's the first time I show up on Facebook, right? And we even had a cat video included. That's great. I mean, this is not what Facebook is all about.
No.
All
yeah,
right. Sorry, Professor. All right. Harry has a question.
Thanks, Jifeng. And thank you, Professor Alvarez, for giving us this wonderful presentation. I was wondering if you could tell us a little bit about book projects. I know you said you didn't have time to go through it, but just in case you had any sort of advice that might be different than submitting in a law review journal.
Sure. So I would start with the Cambridge University Press advice, and you will see that book publishers expect certain things. They want you to submit at least 2 chapters of the book with an overall framing, and they want you to be clear about what the thesis is. But they also want you to do your homework as to who the market is. They want you to explain who would want to read this book and why, given the literature around this topic is important. Because remember, a book, unlike an article, is supposed to have even more legs than an article. It's supposed to last a little longer. And therefore, a publisher is entitled to know who do you think will buy this book. The other thing that they often warn people about is if it was originally a dissertation, it shouldn't just be the dissertation. Not because a dissertation isn't good, it might have fulfilled its purpose beautifully, but because a dissertation and a published book for a readership is somewhat different audience. So they would want you to indicate how you are intending to change from the dissertation to the book. And they want, for instance, for you to put more upfront the thesis, decrease the exploratory research that it shows your dissertation supervisor that you've done your homework, but you don't need to do that with a reader. So it could be, in some ways, shorter and punchier because of that. They also want you to, they put it this way, be more confident. And therefore, that means your thesis should be a little bit more cutting edge. That is, push it a little bit, just to the brink of where you're uncomfortable, perhaps. But in other words, make the thesis attractive and novel, perhaps in a more daring way than you would to your dissertation committee. Okay? And so that's part of it. You should not, generally, they don't want to see past publications. They want to see a CV. They may ask you for who else you're submitting to. If it's a interdisciplinary project, as many of them are these days, you should know that they will submit it to both, say, the political science editor as well as the international law editor. of CUP or OUP in terms of what they're looking for. Both Tom Randall at CUP and Marcel Alstein at OUP told me some of the same things, surprisingly. They see a trend right now of a return to history, serious history. They want, for example, Gary Simpson, and looking at the Cold War as a period of time where there was considerable change underneath the surface of this apparent paralysis between the US and Russia. But a close look at history, how it matters, in part because they think that history will continue to be read. If you do a good job, this is the kind of book that will continue to be read. They also have a continuing interest in the classic sources for the same reasons. They have more general readership of treaties generally, if you have an ambitious new angle on treaties. And they also are particularly interested in topics that have not received, in their view, sufficient attention. So that could be, for example, environmental topics, but they are worried about and sort of warn me against too timely topics. They are probably not going to accept your latest book on COVID, okay? They're up to their ears in COVID right now. And like everybody else, they're probably sick of COVID themselves. So therefore, it's unlikely that a topic like that will penetrate the huge amount of scholarship that is already emerging on that. So be careful about topics that are so timely that they're not going to be timely by the time you finish the project. So those are some of the things they've suggested with respect to book projects. And I do think that you have to give them an accurate sense of the expected length and stick to it, as well as the expected timeline for completing the project. They do put in some time in judging your book project. They submit it to peer reviewers. And if you go through that trouble, they want to know that you're serious. So it's not something that you would approach just as a lark, obviously. But there are opportunities. Both of those publishers publish about 100 books a year, each one, on international law topics. So there is quite a bit of opportunity here. And some of them have relatively small audiences. That they're quite clear about that. They don't mind a book on the continental shelf, even though that may have a rather limited audience, if it's a really good book that is likely to last on that topic. And they have controls over that. They can publish a limited amount and then have a new edition or publish a new batch of them as needed if it's assigned in class, for instance.
Okay, thank you. Up next, Violet has a question.
Thank you, Professor. It was very informative. So I just have a question about if I want to publish on comparative international law. So I think one issue is that you're not trained in that area of law. For example, you're not trained in US law, you're not trained in German law. Then how do you approach the issue of writing about comparative international law?
So that is a serious, hard issue. If you look at what has been published, including in this book on comparative international law that I mentioned by Anthea Roberts, if you look at the chapters in it, most of the chapters are people writing from within their own domestic system. So a Russian scholar writing about Russian perspectives on international law is what you would expect. That is, it is very hard for somebody outside a legal system to master it enough to do that. Now, of course, if you are, say, a Russian expert on international law in Russian courts and Russian statutes that have addressed this, you can say a few words by way of comparison to how another country deals with the same issues, but without the depth. You could look briefly at the UK's treatment of the same treaty, for instance. You could compare whether that particular treaty is regarded as self-executing without implementing legislation in a couple of places. And there are scholars, I can think of one in particular, for instance, that took a treaty, for instance, CEDAW, and examined how different courts around the world interpreted particular provisions of CEDAW, so that the starting point is the treaty, and then looking at different versions of it as interpreted by different national courts. Now, another word of warning on comparative law that makes it very difficult is that if you're looking at case law in translation, that can be a problem, right? So as I think it was mentioned, I'm now heading up the US Asia Law Institute. And we just have a course that we've just created on globalization, international law, and East Asia. And we wanted to take a look at some foreign cases dealing with international law issues. And one of them was the famous case from the Supreme Court in South Korea dealing with forced labor. One of the problems is that, of course, that was translated from the Korean, and none of us really knew for sure how close that translation was. And if lawyers all know, it's all about language. So looking at something in translation is particularly difficult. So that's another piece of advice, that if you're serious about comparative law, having the language of the particular country or region that you're focusing on is pretty essential.
Thank you.
Okay. I think there's just one, Gaziping, I see a couple more comments you want to just read those.
All right. Angus Neo from Ministry of Law, Singapore has a question. Hello, Professor. As a civil servant, I have my own reservations about what I should write about. I fear it may reveal my personal opinions on certain topics when I may be involved at work. For example, at a negotiating table, or suggest something, be it rightly or wrongly. Do you have any tips on this matter?
Well, this is a sensitive question, whatever ministry you're in. At the State Department, certainly the years that I was there, I was certainly told that if you're writing about something that you were working on, you had to actually have clearance. Not because you're using confidential materials or anything like that, but because despite that first footnote that will say this is your own personal opinion, many people won't see it that way. And so I was very cautious about writing on anything that I worked on. And so I really didn't. And so the closest thing was probably my first article, which was about the creation of the Committee on Foreign Investment Screening in the United States, which happened during my watch at the State Department. But the truth is, I had very little to do with it, but I had followed it closely. So my first article was called the Exxon Florio Law, from the two senators, one senator and one representative, who proposed it in the Trade Act. And it's turned out to be, a piece that is sort of the legislative history for a statute that's become quite significant. As you probably know, investment screening is now occurring all over the world. And of course, the US CFIUS, the Committee on Foreign Investment, has become quite active now, especially with respect to screening Chinese investments. So the article is still read. So what I would urge folks that are in the government to do is to look for a topic that may use your skill set, but not something that you actually worked on that would raise those sensitivities. And of course, if you are still in the government, you obviously have to include that disclaimer that nothing represents your government's views, it's your own personal views. But to be safe, if it is something that is in your portfolio as a lawyer, you should probably get clearance.
Okay, very good. I think we have gone over time, but well worth it. I know that there was one comment from Evgenia, so I will read that. Thank you so much for the lecture, Professor. It is both illuminating to have someone tell us how it works from the inside and inspiring to see that tough as the screening and decision process is, it isn't some mysterious club closed for any newcomers or outsiders. So I think you've actually given encouragement and inspiration to our students, which is important. I think that really is. We need to encourage the new talent coming out from all parts of the world. So I think this was really a very helpful. I think you opened up information to our participants that they may not have had easy access to. So thank you. And I think this will have to be a tradition for the Academy to have, at least for this topic. We will certainly engage you for other things as well in the Academy. But this is very important for aspiring and even established scholars. So thank you so much for taking the time to be with us. And really, we had a very good turnout for this. So enjoy the rest of your day in New York. I know for Singapore it's late, but well worth it for all of us. And on behalf of myself and Patricia, the CIL eAcademy, and CIL, we thank you so much, Professor Alvarez. And see everyone tomorrow for our next lecture. The Academy continues.
Bye-bye.
Bye-bye. Take care. Bye-bye.